Please be seated.
Well, good afternoon, everyone. My name is Susan Duncan, and I'm the Dean of the Law School, and it is so great to see all of you here to see this exciting finals. I know you are in for a big treat today, great advocates. So really, so sad that I've got to go to another meeting because I'd love to watch you all. But first of all, I just want to thank Judge Burden for being with us. It's always great to see you and have you back. And also, of course, the wonderful attorneys from the Dale Steen Dale and Pace firm. You know, they've been doing this for 39 years. You're just talking, next year it's going to be the 40th anniversary. So for a long, long time. And we are so grateful for your continued support. This is a highlight for these students in the fall. And we've had such great trial teams the last few years. I want you all to make sure you look at those banners on the outside because there's some real recent victories out there. And we know that the trial competition and the trial ad board would not be as successful without you all. So these attorneys give up a lot of billable hours when they come up here all day. So if we could just give them a round of applause. I also want to thank Katie Hesper. I don't know what she's back there. She's our advisor, our faculty advisor. She does a great job. I think judged a lot of rounds this week. So thank you, Katie, for all your help with the trial ad board. And then most of all, the trial ad board. Gosh, we just couldn't do it without you all. You're fantastic. It's fun to see you all go out to those competitions and bring home these great victories. You're great recruiters. I have students all the time coming to the law school, and I get to brag about you all, and you help us recruit. So thank you so much for that. I've got a really special announcement this year. There's going to be a $500 scholarship to each winner. So the team that wins, each of you will get $500 from Kelsey and Andy Seeger. They wanted to give this gift in memory of their classmate that passed away. I think their classmate might have been a winner of a former.
He was a classmate of mine in law school in 2004 and was the runner-up in the competition our last year in law school.
So we're just so touched that they want to remember him in this way. So they contacted us, and so whoever is the lucky winner today will get a $500 scholarship. So we're very appreciative of the Seegers for remembering your all's classmate.
Does that go to them or to the bursar?
They'll go to the bursar. So you know, you know how that works. So I have to run into a capital campaign meeting. Unfortunately, I'd love to be with you all, but need to get some money for y'all too. So need to do that. But I'm going to introduce you to Mr. Bill Dallahite. In my 6 years as being dean, he has just been a wonderful attorney to get to know. He's been so supportive of the law school and the law students and me personally. So thank you, Bill, for everything you do for us.
Absolutely.
Okay, you all have a great round. Good luck. And I can't wait to rewin.
When we first started this, the winners actually got checks. Seriously, we gave each winner a check. And then somebody wised up halfway through the process and realized that there was some student debt involved. So they took those checks away and gave them to the person. So I tried today, but I didn't think I had much success with her. We want to thank Judge Burden, who is the United States Magistrate for the Northern District of Mississippi from Greenville. She's a graduate of the school as our presiding judge, and she will make all four of you work very hard. We have sponsored this, as the dean said, since 1982. Tom Mason, who probably none of you know, was a professor here, and he called our firm to make this suggestion to do this because he was worried about students not getting on their feet in a courtroom setting. So this is where that started. I think the first time it was done was 1983. So 39 years, a long time. This is our firm, Seth McCoy, Anna Livingston, Lanny Pace, and myself. It's important that you remember that we are evaluating each student, not the vehicle. The vehicle is the case, the elevator case, the grain elevator case, but that's the vehicle that is used to get them on their feet. They will each do different parts of the trial, but every time they stand up, whatever it may be, they will be evaluated by us and by Judge Burden. We'll go back and each of us, including Judge Burden, has a vote, and we will decide who the winners are at the end of this. Do we have any veterans in the room? Am I the only veteran in this room? There you go. Thank you for your service. I am proud to be a veteran, and I think of it as the rent that I pay for the peace that I enjoy. So happy Veterans Day to you and me. John?
Thank for those remarks and for your service. All right, ladies and gentlemen, we are here this afternoon for the case of Valley Roads versus Armadillo Elevator Company. Our juror is in the box, our jury is in the box, ready to proceed. Our counsel ready to proceed, starting with the plaintiff.
Yes, Your Honor, we're ready to proceed.
All right, is defense ready?
Yes, Your Honor.
All right, first I'd like counsel to, if you would introduce yourself and your client to the jurors.
Your Honor, my name is Joshua Clardy, along with my co-counsel Mia Fontenot. We represent Bailey Roads in today's case, and we are the plaintiff.
All right, thank you.
Her name is Carly Chin. I'm Stephanie Tunstall, and we're here to represent Armadillo Elevator Company.
Thank you. All right. Are there any further pre-trial matters the court needs to hear? Take up the time.
No, Your Honor.
All right, are the plaintiffs ready to proceed with your opening statement?
Yes, Your Honor, we're ready to proceed.
You may do so.
Your Honor, opposing counsel, Mrs. Rhodes, members of the jury. Armadillo Elevator Company, or AEC for short, is a grain elevator company. Now, AEC needs three things to run their business successfully. The first thing that they need is rail tracks and rail cars. Pretorius Railway and Brew Company supplies that for AEC. They deliver the specified number of rail cars to AEC. AEC then loads those cars with grain, and Pretorius only returns to take those away when AEC is ready. The second thing that AEC needs is power line. Big State Power Company provided that power line to AEC. That power line, it only serviced AEC. It provided power to one of their fertilizer tanks. The third thing that AEC needs to run their business is a grain sampler. Because federal law states that AEC, they cannot sample their own grain. So they have to hire outside grain samplers. And that brings us to today's case. Mr. Rhodes, he was a loving father, a great husband. He taught high school chemistry here in town. But on June 16th, 2020, Mr. Rhodes was a grain sampler for AEC. On June 15th of 2020, Rocky Roads went out to AEC to sample their grain. He looked around and he decided that it would be too muddy for him to start sampling. He decided that it would be unsafe, so he went back home. The next day, on June 16th of 2020, Rocky Roads went back out to AEC to sample grain. The only thing that was different that day, Rocky didn't make it back home. Members of the jury, my name is Mia Fontenot, and along with my co-counsel, Josh Clardy, we're here today to represent Mrs. Rhodes, Rocky's wife. Now, we as the plaintiff have the burden of proof in today's case. We have to prove to you today that Armadillo Elevator Company was negligent. And this burden that we have is by a preponderance of the evidence. And preponderance of the evidence simply means more likely than not, 50.01%. And for right now, just think of negligence like this. AEC caused harm. AEC didn't warn Rocky of that harm. And AEC, they didn't do anything to stop that harm. Members of the jury, first you will hear testimony from Mrs. Rhodes. She'll get on the stand. She'll tell you a little bit more about who Rocky was and what a grain sampler does. She will also tell you a little bit more about safety instructions that Rocky used. Then you will hear testimony from Mr. Kim Williams. He will get on the stand as a safety consultant, and he will tell you a little bit more about safety procedures and workplace accidents. You will also hear testimony about how AEC was unsafe on June 16th of 2020. Members of the jury, at the end of today's trial, my co-counsel will have a chance to come and talk to you. He'll review all the evidence and testimony with you. He'll offer you some parting thoughts, and he'll ask that you find that AEC was more likely than not negligent in causing the death of Rocky Roads on June 16th of 2020. members of the jury, it is better to be safe than sorry. Thank you.
Can't read it, so.
Yeah. Opposing counsel. Members of the jury. When you don't play by the rules, someone can get hurt. It's June 16, 2020. Rocky Roads is at work. You see, Mr. Rhodes is an independent contractor who samples grain. And on this day, he's out sampling grain on a local railroad track. Now, this track is full of train cars that are filled to the brim with grain. Mr. Rhodes' job is to climb to the top of each car, place his sampling probe inside that car, remove the grain, and test it. He does this often. This day is no different. He goes from car to car sampling grain until he gets to a car that is parked directly underneath the power line. So Mr. Rhodes climbs to the top and he steadies himself. He places his probe inside that car, but this time when he pulls the probe out, it comes into contact with that power line. This contact causes a burst of electricity to run right through that probe and through Mr. Rhodes' body. And this electrocution sends him flying off of that train car and he falls 15 feet to the ground. Mr. Rhodes doesn't come home from work that day. Because when you don't play by the rules, someone can get hurt. Now, members of the jury, my name is Stephanie Pasquale, and along with my co-counsel Carly Chin, we are proud to represent Armadillo Elevator Company in this action. I'm here to tell you about a man who unfortunately lost his life because someone didn't play by the rules. Now, you may be wondering how Armadillo Elevator Company even fits into what I just told you about how Mr. Rhodes died. Well, Ms. Fontenot just sat up here and she made you a promise. She promised to show you that it was more likely than not that Armadillo was responsible for keeping Mr. Rhodes safe, just because they owned the land. But members of the jury, the plaintiff will not be able to meet that promise today. Armadillo did not own those train cars. Armadillo didn't own the tracks, and they certainly didn't build the power line that led to this accident. Because of that, we've taken on our own burden today. We brought you 3 other parties that are more likely than not responsible for the safety of Mr. Rhodes. Now, let's start with the victim, Mr. Rhodes. We don't want to sit here and put all of the blame on the victim, but unfortunately that day there were things that Mr. Rhodes could have done to prevent this accident. And today you'll hear about 2 important safety rules that Mr. Rhodes failed to follow that cost him his life. But again, we don't want to sit here and place all of the blame on Mr. Rhodes. So let's move on to Pretorius Railway. Now they own those train cars and those tracks. And you'll also hear today about their safety director who's supposed to conduct an inspection once a month and how that power line had been there for 3 to 4 years. The evidence will show that time and time again, they ignored their own safety rules by leaving that train car underneath that dangerously low power line. But now, let's move on to Big State Power Company. You're going to be hearing a lot about Big State Power Company today. A safety expert is going to take the stand to tell you that Big State Power Company had their own rules about the height of those power lines, and how the evidence will show that on the day of the accident, that power line was built well below the absolute minimum. The evidence will show you that these parties could have played by the rules, but they didn't. Now, members of the jury, we agree with opposing counsel. This is a tragic accident. This man lost his life and there's no bringing him back. But at the end of today's case, Ms. Chin is going to come and speak with you. She's going to review each party's responsibility and ask you to assign a percentage of fault. And by the end of the trial, we ask that you assign the largest percentage of fault to the company responsible for what actually killed Mr. Rhodes, that power line. Because when you don't play by the rules, someone can get hurt. Thank you.
All right. Plaintiff may call the first witness.
Plan to call Bailey Rhodes to the stand. May I proceed, Your Honor?
May.
Can you please tell the court who you are?
My name is Bailey Rhodes, and I was Rocky's wife of 22 years.
Who was Rhodes?
Rocky was my best friend. He was the best father I could have had for our children, and he was a beloved school teacher. He taught chemistry at Armadillo High, and that was his true passion. But passions don't always pay the bills, so he took up grain sampling on the weekends and in the summers to make a little extra money for our family.
What exactly did Rocky do as a prince?
There's some laws that don't allow the elevator companies to sample grain themselves. So Rocky would go out and do it for them.
And how exactly did Rocky sample?
Well, Rocky would, he'd go on the walkway and you use a grain sampling probe. Essentially, Rocky would stick the probe into the grain, at its pointy end. The other end has a bulb. Once the probe is filled, he would kind of stick it up a little bit so that the grain could flow out of the bottom of the bulb into a grain sampling bag. And then he would send it off for testing.
Now, Mrs. Rhodes, what do you do for a living?
For most of my life, I've been a stay-at-home mom, but I do have an accounting degree, so I do some contract work, for the CPA.
Did you ever go to the work site with Rocky?
I would.
And what would you do with it?
I would just place the grain sampling bags down for him to put the grain in.
Do you remember the walkways on top of the cars?
I do.
How wide were these?
They were pretty narrow.
Now, let's move a little bit closer to the accident. Did anything happen on June 15, 2020?
Yes, Rocky went to go sample some grain at Armadillo Elevator Company and he returned home. The weather wasn't good and it just wasn't safe for him to sample that day.
You mentioned the weather not being good. What exactly about the weather was an issue?
It had rained, it was really muddy. Muddy doesn't provide great traction and Rocky was always pretty careful when it came to falling.
Now, did anything happen? And where was he working on this day?
Armadillo Elevator Company and Armadillo Lone Star.
Now, did anything happen on June 16th? What happened on that?
Rocky left home to go sample grain and he never returned.
Now, on June 16th, 2020, what did you do after this?
I went to the hospital where I received his belongings from the police.
And did you receive anything else along with it?
Yes, I did.
Would you recognize that document you received from the police?
I would.
Your Honor, at this time, permission to review what's been marked as Exhibit 7? Yes. Let the record reflect, I'm showing closing counsel. What's been marked as Exhibit 7? What is this document?
This is the property inventory sheet I received of Rocky's belongings from the police.
And you recognize this document?
I do.
Has it been changed at all since the last time you've seen it?
It has not.
Say it's a fair and accurate version.
I would.
Your Honor, at this time, plaintiff moves Exhibit 7 and evidence is often disputed.
Any objection? No, Your Honor. They'll be admitted.
What shoes are listed on this document?
His favorite pair of Nike running shoes.
And is there any mention of headphones on this document?
There is not.
Your Honor, permission to follow this legit. Yes. Now, did you ever receive any documentation from Austin Grants?
Yes, I've seen it before.
And would you recognize this document that you signed? Yes. Your Honor, permission to retrieve what's been marked as Exhibit 11. Amen. The record reflecting and showing the proposing council has been marked as Exhibit. What is this document?
This is Austin Grain Sampling's procedures and safety rules.
And do you recognize this document?
Yes, I do.
And has it been changed at all since the last time you've seen it?
No,
Would you say it's a fair and accurate copy?
I would.
Your Honor, at the time claimed to the 11. Stipulated.
Any objection?
No objection.
It'll be made.
Now, I want to focus on that last section in particular. Can you please read number 2, the second instruction under the safety instructions area?
Sure, it says, always wear shoes or work boots which have rubber type soles and heels to avoid slipping.
And what type of shoes was Rocky wearing again?
He was wearing his favorite pair of Nike running shoes.
Are there any other rules prohibiting any other types of clothing?
No,
Are there any rules prohibiting any types of accessories?
no,
To your knowledge, did Rocky ever break any of these rules?
my knowledge, no.
Your Honor, permission to publish the return.
You may.
No further questions. I tender this witness for cross-examination.
Your Honor, may I have a moment to pose the law?
You may. Sorry.
Permission to proceed.
You may.
Good afternoon, Mrs. Rhodes. My name is Stephanie, and today I'm just going to be asking you a few yes or no questions. Feel free to answer yes or no, but if you have any questions for me, just let me know. So, Mrs. Rhodes, you mentioned that you've helped Mr. Rhodes sample grain sometimes, correct?
Yes,
And before sampling grain, you're aware that he signed some grain sampling safety rules.
yes, I have seen them.
And you'd recognize Mr. Rhodes' signature, right?
Yes.
Okay, I'm now approaching opposing counsel with what has already been entered as exhibit 11. Approaching the witness with the same. Mrs. Rhodes, that is that document of safety rules, correct?
Correct.
And has anything been changed or altered about that document?
No.
Is that the same document you've seen in your deposition?
Yes.
Mrs. Rhodes, if you flip to the end of that document, that is Mr. Rhodes' signature, correct?
Correct.
Thank you, Mrs. Rhodes. Now, this next part might be a little more difficult for you, but I'd like to move on and talk more about Mr. Rhodes. So if you need a break, please let me know. But when you would go up on those grain cars with Mr. Rhodes, those grain cars, he warned you about slipping off of those grain cars, correct?
Correct.
But did Mr. Rhodes ever warn you about getting into the power lines above your head?
He did not.
Now, will you read from exhibit 11 under safety rules, number 5?
It says, be sure that your grain probe does not come down closer than 6 feet of any electrical lines at any time. If you notice any situation where this poses a problem, be sure to report it to the loading elevator. Report it to us by phone, confirmed in writing with the exact location.
Thank you, Mrs. Rhodes. Now, let's talk a little bit more about when you would help Mr. Rhodes with the grain. You mentioned that you've helped him in the past, but on the day of the accident, you weren't actually there to help him, correct?
I was not.
So you're not able to tell us exactly what that scene looked like that day?
No.
And you've seen a picture of the sampling probe Mr. Rhodes was using that day, but you didn't actually see it in person?
Correct.
So you can't tell us exactly how Mr. Rhodes was pulling those grain samples that day?
On that day, no.
So you're not able to tell us if Mr. Rhodes was following certain safety rules the day of the accident?
No.
And Mr. Rhodes, you're aware that he was an independent contractor with Austin Grain Sampling?
He did work for Austin Grain Sampling.
And you're also aware that Mr. Rhodes was a high school chemistry teacher who sampled grain on the summers and on the weekends?
Correct.
Thank you, Mrs. Rhodes. I just have a few more questions for you.
Your Honor, requesting so I can better see the demonstrative at this time.
You may.
Now, you mentioned that you've been on top of those green cars.
Don't block.
Oh, sorry.
Sure.
You mentioned that you've been on top of those grain cars before. Those grain cars were 15 feet tall, correct?
Correct.
And Mr. Rhodes was 6'1".
He was 6'1".
So if you have a 15-foot rail car plus Mr. Rhodes' height of 6'1", that would be 21 feet, 1 inch, correct?
That is correct.
And if that power line was 24 feet, 2 inches
Objection,
off the
Your Honor.
ground,
Lack of personal knowledge, this witness does not state anywhere that she knew the height of this power line.
Your response.
Your Honor, this demonstrative is just talking about what Mrs. Rhodes previously testified in her deposition, but as far as the height of the power line, Mrs. Rhodes is a party to this lawsuit, and this is an undisputed fact in this lawsuit. Mrs. Rhodes is the one who brought the suit.
All right, I'll allow.
So if the height of the power line was 24 feet, 2 inches off the ground, that would leave about 3 feet of space between Mr. Rhodes' head and that power line.
Yes.
Mrs. Rhodes, this would be the distance between Mr. Rhodes' head and that power line.
Yes.
Thank you, Mrs. Rhodes. Your Honor, I have no further questions. Yeah, no further questions. Thank you.
May this witness be released.
Your Honor.
All right, I'll allow
Mrs. Rhodes, were there
it.
any? May I proceed?
No, you may not. Let's let, but we'll get clear. All right, now,
Mrs. Rhodes, were there any power lines at the work site you went with Robin?
No, there's never any power lines. We are always at the edge of town and there's no power lines up there.
So what safety instructions did Robin?
He taught me how to walk from rail car, and he stressed the importance of falling.
No further questions, Your Honor. This witness has.
all right, you may step down.
Your Honor, I left them down the podium. Can I record it?
Does the plaintiff wish to call any further witness?
Yes, Your Honor. The plaintiff would now like to call Mr. Kim Williams to the stand.
Mr. Williams, step forward, please. Have a seat.
May I proceed, Your Honor?
You may.
Good afternoon. Can you just state your name for the record for us?
My name is Kim Williams.
And what do you do for a living?
I'm a safety consultant. I've been for the last 5 years.
What brings you to court today?
I was asked to investigate and testify if necessary on the death of Mr. Rocky Rhodes that occurred on June 16th, 2020.
And are you being paid to be here today?
I am.
I want to back up and talk about your background just a little bit. Do you have any professional degrees?
I do have a degree in industrial safety engineering from Lone Star University.
And you mentioned that you were a safety consultant now. Have you ever had any previous jobs?
Yes, prior to being a safety consultant, I was a safety inspector for OSHA for 25 years.
What did you do as a safety inspector?
Safety inspectors have 2 jobs mostly. The first job is to go out to work sites, make note of any OSHA violations and cite the company. The other job is to investigate accidents, usually involving death or serious injury.
About how many accidents would you say that you've investigated in your time with OSHA?
Approximately 600.
And how many accidents have you investigated in your time as a safety consultant?
Dozens.
And did you have to complete any training to work for OSHA?
Yes, when I started my career at OSHA, they put us through a rigorous training course.
Have you ever been published before?
I'm not. Safety inspectors don't write books or anything, but I do write expert reports
And have you ever testified before?
dozens of times.
Your Honor, at this point, we would move to formally certify Mr. Kim Williams as an expert in the field of workplace accidents and workplace safety under 702A.
Any objection?
I agree with Your Honor.
All right,
Afternoon, Mr. Williams. You worked for OSHA for 25 years, right?
Yes,
And your major opinions in this case are based on violations of OSHA standards, right?
Yes,
I reviewed your deposition and OSHA was mentioned about 19 times on 7 pages. Do you have any reason to dispute that?
I don't.
And it's fair to say that you're very well versed in OSHA standards, right?
Yes,
And OSHA would apply to employers and employees, wouldn't it?
it would.
And you render an opinion in this case that Mr. Rhodes was an employee of Armadillo, correct?
Objection, Your Honor. This board order is about the qualifications of this witness, not his conclusions or anything else. That is under 702B or D. We're merely talking about his qualifications here.
I agree. Limit your question to this qualification.
Your Honor, at this time, based on his own admissions of his qualifications and opinion related to OSHA, they're irrelevant in this case. OSHA only regulates employers in the workplace, but we know that Armadillo is not Mr. Rhodes' employer because this is not a workers' compensation case. We ask the court to preclude any testimony of OSHA conclusions from his investigation.
Your Honor, may I respond?
You may.
Under OSHA, AEC was a work site, and Mr. Williams will give further testimony as to that. He will lay that foundation of why AEC is considered a workplace under OSHA's regulations, and therefore all of OSHA's regulations, which he will be testifying to, will suffice that opinion.
All right, I'll accept this witness as an expert in the field in which he's being audited.
Okay, continue, Your Honor.
You may.
What facts and data did you rely upon in today's case?
I reviewed all 21 exhibits, including the depositions of Ms. Bailey Rhodes and Chris Kitchell. I also went out to the AC website to have a look at it for myself.
Did you say that this was a sufficient amount of information?
Yes, there's a lot of information.
And what methods do you use when you go out to investigate accidents?
I use my training and experience in investigating several hundred accidents to OSHA, as well as my current experience as a safety consultant. I also reviewed all applicable laws and regulations.
You say that these methods are reliable,
Yes, they are,
and did you reliably apply the facts in today's case with your methods?
of course.
And were you able to reach any conclusions in today's case?
Yes, I reached several conclusions.
What was the first conclusion that you reached?
First, I concluded that under OSHA's definitions, the top of the rail car constituted a work surface.
What made the top of that rail car a work surface?
Well, railroads usually govern something like this, but OSHA governs in this case because AC had a non-railroad employee by their invitation with knowledge of their whereabouts doing work for their benefit.
And you mentioned several conclusions. What was the second conclusion that you came to in today's case?
Second, I conclude that AC was the controlling employer under OSHA's definitions.
What made AEC the controlling employer?
Federal law says AC can't sample their own grain, so they have to contract people like Rocky to do the sampling for them. AC had ultimate responsibility over Rocky, and they had the ultimate say so with the premises.
Were you able to reach any other conclusions in today's case?
Yes, I conclude that the work surface presented both a fall hazard and an electrocution hazard.
What made the work surface a fall hazard?
Well, you have a 3-foot wide walkway that's 15 feet in the air. AEC as the controlling employer had a duty to provide rocket fall protection under OSHA's regulations, to which AC did not do.
What is that OSHA regulation?
The OSHA regulation states that employer has the duty to ensure that employee has fall protection equipment when that employee is on a work surface higher than 4 feet. Since AC was the controlling employer of the work surface, AC had a duty to provide rocket with that fall protection equipment.
And after reviewing all the evidence in today's case, could anything have heightened that fall hazard?
Well, as AC's owner, Chris Kitchell mentioned several times, AC was continuously pushing the rail cars in the same direction and on the same rail track that Rock was on at the time of this accident.
And you mentioned an electrocution hazard. What made this work site an electrocution hazard?
Well, a power line crossing a rail track doesn't necessarily create a hazard, but AC put workers on top of the rail cars without disclosing to Big State Power Company that people would be in such close proximity to the power line.
Was this power line in violation of any safety regulations?
Well, yeah, it was over the spur track, it met the safety regulation, but over the, over the main track, it met the safety regulation, but over the spur track, it did not.
What is that safety regulation?
The regulation states that the power lines must be 26 feet above the railroad tracks when covered with ice.
And you mentioned that it was not in violation of the spur, or it was not in violation of the main tracks, correct?
No, it's not.
In your expert opinion, was Pretorius Railway negligent in causing Rocky's death?
No, Pretorius Railway only supplies the rail cars to AC. Pretorius Railway left the work site at AC at 3:22 p.m. on the day of the accident. So Pretorius wasn't even on the site. Plus Pretorius Road checks the rail tracks twice monthly to ensure that they're safe for use.
And in your expert opinion, was Big State Power negligent in causing Rocky's death?
Well, Big State Power owns the power line, but AC requested Big State Power put this line in. Also, AC didn't inform Big State Power that people will be walking on top of the rail cars. This would have been material information for Big State Power to know. And Big State Power erected a tall pole to ensure the power line would be within the NESE regulation.
In your expert opinion, was Rocky Rhodes negligent in causing his own death?
No, Rocky went to the AC worksite on June 15th, determined as unsafe and went home. And so he sampled the grain the next day.
In your expert opinion, was AEC negligent in causing Rocky's death?
Yes, as a controlling employer, AC had the duty to provide Rocky with fall protection equipment. AC should have told Big State Power Company that the material information that people will be walking on top of the rail cars. And AC should have warned Rocky of the power lines. AC should not have been actively pushing rail cars in Rocky's directions while they knew he was on top of the rail cars.
No further questions, Your Honor. I consider this witness for cross-examination.
You may call.
Before I get into your investigation and what happened to Rocky Roads, I want to ask you a few questions that I think we could both agree on. Is that all right?
Sure.
Safety rules and standards are critically important, wouldn't you say?
They are.
As a matter of fact, you've dedicated your life to safety in the workplace.
I have.
And if an employee violates safety rules, you would certainly agree with me that someone could get hurt.
They could.
And if an employee violates safety rules, you would certainly agree with me that it could be the difference between life and death.
Good.
Now, Mr. Williams, I'd like to talk a little bit more about you. You used to be a safety inspector, right?
Yep.
And you left that job to become a consultant.
I did.
You became a consultant because you make much more money testifying in cases just like this one.
I do.
Now I'd like to talk about the victim in this case, Mr. Rhodes. Now, Mr. Rhodes was not employed by Armadillo Elevator Company, was he?
He's employed by Austin Grain Sampling, which AEC hired out.
So no, he is not an employee of Armadillo Elevator Company.
Well, like I said in my prior testimony, AC was the controlling employer.
But he is not employed by Armadillo Elevator Company. He is an independent contractor through Austin Grain Sampling, right?
Yes,
Thank you. Now, you know that Austin Grain Sampling has their own safety rules and procedures, right?
they do.
And you would recognize a copy of this, correct?
I would.
I'm gonna hand the witness what's already been entered as exhibit 11. Those are those safety rules, right?
Yes, ma'am.
You actually reviewed these safety rules when coming to a conclusion in this case, didn't you?
I did, ma'am.
And you're aware that Mr. Rhodes signed these rules stating that he understood them.
Sure looks like it.
Now, would you please direct your attention to line 5 on page 2?
Yes, ma'am.
It states that no grain sampler should bring their probe within 6 feet of any power lines, doesn't it?
It does say that.
And on the day of the accident, isn't it true?
Objection, Your Honor. We believe that this line of questioning is going to lead itself to speculation. While this probe did hit the power line at the time of the accident in question, no one here can testify as to where the probe was anytime before the accident. He could have been 10 feet away and been pushed into this power line. We're uncertain of that, and he's uncertain of that. He lacks the personal knowledge to continue on with this testimony.
Well, I didn't hear a question actually posed. I heard the start of the question, so let's get the question out and then I can take up the objection.
So on the day of the accident, isn't it true that that grain probe came within 6 feet of that power line?
Don't answer now, it's your objection.
We would re-raise the same objection. While the probe did come in contact with the power line, we have no way of knowing whether the probe was within 6 feet at any time before the accident actually occurred in that very instance. He lacks the personal knowledge to know where Rocky was 10 minutes before the accident or even 1 minute before the accident.
Who wants to respond?
Your Honor, I'm not talking about 10 minutes before the accident. I'm asking if at any point throughout the day that grain probe came within 6 feet of that power line. And fire and counsel's own words, it did.
I'll allow the question.
So So on the day of the accident, isn't it true that this grain probe came within 6 feet of that power line?
It did come into contact with the power line.
So that's a yes.
Yes, ma'am.
Mr. Williams, I'd like to talk to you about some of your other opinions in this case. One of your opinions was that Armadillo was a controlling employer on the site of the accident that day, correct?
Yes,
And in your depositions, you said that the basis of this opinion was nobody else had any person out there doing any active work, right?
yes.
You also said the railway didn't have anybody out there, didn't you?
I did say that.
Would you like to change that answer?
Well, like I said in my, I think in the cures I reviewed, Pretorius left that day at 3:22 p.m. So I'm not sure what the question is.
You reviewed Alexander Bell's sworn statement when investigating this case, correct?
Yes, ma'am.
And Mr. Bell is that safety director, I believe you were just referencing to, right?
Yes, ma'am.
And he stated that his employees were helping move and spot cars that day, didn't he?
Did.
And Mr. Bell stated that their engineers and locomotives were on the site that day, didn't he?
They were.
Now, you have no reason to believe that Mr. Bell would lie in his sworn statement, do you?
No, I don't.
I'd like to turn the focus now to Big State Power Company. They owned and built those power lines, or the power line on the day of the accident, correct? Well, no, they did not build it on the day of the accident, but they built that power line, correct?
Yes, ma'am.
And when you visited the scene, the line was clearly visible to you.
Like I said in my, I believe I said priorly, when I was on that rail car, I was so high up in the air, I was hardly looking up and down to see the power line. I don't think I would have noticed it.
So it's your testimony today that you said that you're saying you did that line was not clearly visible to you?
That it was clearly visible?
Yes.
No, but I said it was visible, but I wouldn't be paying attention to that because that's so high up in the air.
Mr. Williams, I'm gonna read from your deposition. Do you recall giving a deposition for this case?
I do.
I'm gonna read this question to you and read also your answer. Was the power line pretty obvious when you were standing on top of the rail car? Answer, well, the power line was clearly visible to me.
Objection, Your Honor. We would ask, there's more to this sentence. We would ask under the rule of completeness that she continue to read his answer.
I'm happy to read the sentence.
Please do.
Well, the power line was clearly visible to me that I was looking for it. So that line was clearly visible to you, wasn't it?
Like I said, though, I was looking for it.
And as a matter of fact, the line was clearly visible to you despite spending that afternoon looking at your feet.
Yes, ma'am. As I said, I was looking for it.
But this line did not meet the appropriate safety rules, did it?
Over the spur tracks, no.
That power line was supposed to be 26 feet, correct?
With ice, yes,
On the day of the accident, that power line was 24 feet and 2 inches.
I believe so.
So that's a rule Bay State Power Company did not follow when building that power line, correct?
Yes,
Now, Mr. Williams, you also reviewed the police incident report when investigating this case, didn't you?
I did.
And you'd recognize a copy of that if I showed it to you?
Sure would.
Now, that's that police incident report, correct?
Yes, ma'am.
And you're aware that Big State Power Company was also asked to put a disconnect on that power line, aren't you?
Let's see here. You mind directing me towards that?
Yes.
That's what it says.
And they were asked to do that so it could be de-energized when it was not in use, right?
Yes, ma'am.
And you're aware that that disconnect was not put in, was it?
That's what it says.
And you're aware that the reason they gave was that it would cost too much.
That's what it says.
And you're also aware that Mike Gershon made a statement to the police, aren't you?
Objection, Your Honor. This is hearsay within hearsay. We would ask counsel find an objection or find an exception to the document itself, and not only that, but the statement that she's about to refer to as well.
Again, I'm not, the objection is coming so quickly. It's preceding the question, so I don't know if y'all know what the question is, but I don't. So let me hear the question, and then I'll take up the objection.
In that same police report, you noticed that Mike Gershon gave a statement, correct?
Says that, yes.
And after reviewing that document, you became aware that Mike Gershon said it was only a matter of time before someone got into those power lines, aren't you?
Objection, Your Honor. We would re-raise our objection to hearsay within hearsay. We'd ask that question be stricken from the record.
This is admissible under Rule 703. This expert has testified that he reviewed this document when coming to a conclusion about this case. An inadmissible testimony is allowed if the probative value would outweigh the prejudicial effect. The jury absolutely has value in listening to testimony on why he used this document to come to a conclusion about this case.
I'll allow.
So again, according to Mr. Gershon, it was just a matter of time before someone got into those power lines.
That's what he said in the police report.
No further questions.
Can you redirect counsel?
Briefly, Your Honor. I just want to ask briefly about AEC. What duty did they have to Rocky Roads the day of the accident?
Like I said, AEC had the duty to provide all protection equipment as well as warn Rocky of the risk of the electrocution hazard.
And wasn't AEC, didn't they have an active role at the time of the accident as well?
They did, like I said, as I reviewed all the evidence, today's case, they were moving cars on his rail line in his direction while he was working.
No further questions, Your Honor.
This witness may step down. The plaintiff counsel, we should call in further witnesses.
No, Your Honor, we have no further witnesses at this time. We would like to rest our case.
Your Honor, at this time, the defense would like to move for a motion for directed verdict under Rule 50. May I be heard on this?
You may.
There is actually evidence that a reasonable jury could use to find that the other party's negligence in this case and not Armadillo's was the sole cause of Mr. Rhodes' death. We heard testimony today from plaintiff's expert that Big State Power Company was responsible for building and maintaining those power lines that ultimately killed Mr. Rhodes. And we also heard evidence that Pretorius Railway might have been the reason the rail car was underneath the power line, as they had their engines out there pushing cars on the day as well. So even when viewing the evidence in the light most reasonable or favorable to the plaintiff, a reasonable jury could still find that Armadillo was not the solely responsible for Mr. Rhodes' death. And with that, we respectfully request that the court grant this motion.
May I respond, Your Honor?
You may.
Your Honor, we've met our burden so far to prove beyond the preponderance of the evidence that AC was negligent in this case. The same witness testified that AEC failed to provide fall equipment, failed to provide notice for various hazards on the work site, and also was pushing cars at the time of the accident on the same railway as Mr. Rhodes, which we believe is the major negligence in this case. The witness also testified to the fact that Pretorius had left by the time of the accident at 3:22. We believe that we have shown that AEC has at least some negligence and that this should be questioned.
All right. The court is going to deny this motion for directed verdict, and we will proceed with the case at this point. All right. Does the so we have the defense. We should call its first witness.
Yes, Your Honor, the defense now calls Mr. Chris Kitchell to the stand. Good afternoon, Mr. Kitchell. Will you please state your name to the jury
My name is Chris Kitchell.
and where do you live?
Clackamas Lone Star, just outside of Armadillo.
What do you do for a living?
I own and run Armadillo Elevator Company.
How long have you owned Armadillo Elevator Company?
Seems like all my life, which is 75 years, but no, only 45 of those years.
So why are you here today?
I was at the scene of the accident on June 6th.
Now, Mr. Kitchell, I want to talk to you about that accident. Had you seen Mr. Rhodes at any point prior to June 16?
Yes, I actually saw him on the day before, on the 15th.
How did you come into contact with him on the 15th?
So he came out that day to sample grain and to look at the site. He told us that it was too muddy and that he might get his boots wet and muddy and slip off the walkway.
Now, did he come back the next day?
Yes, around 1 o'clock PM the next day to sample the grain.
And can you describe what that process looks like?
Yes, so he started at the far south end of those cars and placed grain sampling bags on the top of each one, just walking along the top, dropping the bags. And when he got to the farthest car on the north, he grabbed his grain probe and started back going down south, to sample.
Now, do you remember where you were that day, the day of the accident?
Yes, I was at the elevator that day.
Do you remember what you were doing?
So I was up on an elevated platform, which is where we load the rail cars. It's right next to one of the main elevator tanks, so saw it all happen.
Now, I want to talk to you about the moments leading up to when Mr. Rhodes died. At the time of the accident, were you looking at Mr. Rhodes?
Yes, I was looking right at him because I had gone to the south window to see where he was. We were pushing some cars in his direction and we wanted to make sure that we didn't accidentally bump into him and knock off the cars that he was in.
And what did you see when the accident happened?
So I saw him stab the probe down into the hopper and then pull it out and swing it back upside down to empty it. That's when I saw a bright flash and it made me realize that he had come into contact with that.
So what did you do next?
So we shut down the loading that we were doing. When we ran down the steps to help him. I called 911 right away and checked to see if he had a pulse. Didn't seem like he had a pulse, but we did some CPR anyway.
Thank you, Mr. Kitchell. Now, would you recognize a photo from on top of a grain car from when that accident happened?
Yes,
I'm now approaching opposing counsel with what has been pre-marked as exhibit.
Objection, Your Honor. We would object. This is not an accurate viewpoint of where this accident occurred. The accident occurred 460 feet away from the loading platform. We do not believe that that is an accurate depiction of 460 feet away from the loading platform. Additionally to that, we do not know when this photograph was taken. It said that it was taken at the time of the accident, but like I said, it's not an accurate depiction of 460 feet.
Go ahead.
Your Honor, Mr. Kitchell has said that he has seen this before, so we were just going to admit this as evidence because he's seen this grain car in person before.
Well, the witness will need to lay a foundation for it, and I'll allow you to do that.
Mr. Kitchell, what is that photo?
It is a photo taken from on top of the grain car when this accident happened, looking back north.
And how do you know what that is?
I observed the accident when it happened.
Is that a fair and accurate copy of that photo?
Yes,
Have there been any changes since the last time you saw it?
no,
Any additions or deletions?
no.
At this point, Your Honor, the defense moves to admit exhibit 13.
I'll allow it.
Mr. Kitchell, what does that photo show?
It shows a photo of the grain cars we were pushing that day.
And those grain cars, does that have any rail guards on it?
No,
And who owns that grain car?
Pretorius Railway.
Now, can you describe that process you were talking about pushing those grain cars?
Yeah, so me and Pretorius pushed 18 groups of 3 to 4 cars, under the loading platform. We made sure to leave about a 15-foot gap between the car that Mr. Rhodes was on and the next car closest to the loading platform.
Now, why did you leave that 15-foot gap?
So we knew he was out there sampling grain that day, and we wanted to make sure that we didn't accidentally bump into his car and knock him off the car that he was sampling. So that gap was just there to remind us, not to bump into the car that he was.
Thank you, Mr. Kitchell. Now, I want to move on to those power lines that led to the accident. Why did you decide to install those power lines?
So we put in this liquid fertilizer tank about 3 or 4 years ago, and that tank has this big electric pump that we use to pump fertilizer out of rail cars on the spur or pumping in the trucks that come along the loading area on the other side of it. That pump just has this big electric pump that we needed to power.
And who installed those power lines?
Big State Power.
So who all was involved in the installation of these lines?
It was just Big State Power.
So if anything about these lines needed changing, who would do that?
Big State Power.
And who is responsible for ensuring that all the rules were followed when building these power lines?
Big State Power.
Thank you, Mr. Kitchell. Your Honor, I have no further questions, but permission to publish exhibit 13 to the jury.
You may. Cross,
Yes, Your Honor, but before we proceed, may I set up the well with our demonstrative?
you may.
Same issue, because the council wants to Be able to see our demonstrator. Never seen this.
Matt,
Good evening. I just want to jump into the grain sampling. Didn't you say that AEC cannot sample their own grain?
By federal law.
And AEC works almost exclusively with Awesome Grain Sampling, correct?
That's who we were using that day. Yes.
And didn't you say that you work almost exclusively with Awesome Grain Sampling?
I didn't say the word exclusively. I don't recall saying that word.
Do you remember taking a deposition in today's case?
I do.
For the court and the record, or just an accurate copy of your deposition?
Yes.
For the court and the record, I'll read from line. Page 3, line 20. We use Austin Grain Sampling Company pretty much exclusively. And didn't you also state that you didn't know why Rocky was out there that day?
Correct.
But then right after, you stated that you knew Rocky was there to sample grain, correct?
I stated that Dusty Stocker was the one who usually came out there. Sample grain.
And then you stated that you knew Rocky was out there to sample grain, correct?
Yes, I'm 75 years old. It's hard for me to remember.
That's fine. And you'd be familiar with your property, correct?
I would say so.
And you had a survey done of that property?
I can't recall, when we've had a survey done, but
Do you need to be refreshed?
please.
It was exhibit 8, the survey. You mentioned it on page 7, I believe, that you had a survey done. You weren't sure who did the survey, but the survey was done and you've seen exhibit 8. Do you want me to point out the exact line, or is that a yes or no?
I was hoping,
I'm sorry, the witness speak up.
I was hoping she would point out the exact line.
Let me find it for you. Page 5. Line 8, according to the survey, which is marked as exhibit 8. So that's a yes.
Yes,
And you would recognize that survey?
yes,
Is this a fair and accurate copy of that survey?
yes.
Your Honor, permission to use our demonstrative, which is merely an enlarged version of exhibit 8?
Any objection?
No objection, Your Honor. You stated that the loading platform was 20 feet tall, correct?
Yes,
And you stated that from the loading platform to the power line was 460 feet, correct?
correct.
And you would agree with me that that's about a football field and a half away?
Football field and a third.
The math is a football field and a half, but I understand football fields can look a little different. You stated that Rocky Roads started on the east track, correct?
Correct.
And that's because that AEC was done loading cars on the east track, right?
I believe so. It's been a minute since the incident happened.
But the east track was full when Rocky got there, correct?
Like I said, it's been a minute since the incident happened.
Is that an I don't know or is that a no?
And I don't know.
Do you need to be refreshed again?
Please.
Page 4, line 12. I'm gonna read it out loud for you. By that point, we had about 80 cars loaded and we were still loading the other 20. We filled up the east spur track with loaded cars and the west spur track was almost full. Does that refresh your recollection? So the east track,
Excuse me, the witness needs to. probably
Yes.
say yes.
so the east track was full, correct? When
Yes.
Rocky got there.
Yes,
And Rocky arrived at 1 PM, correct?
around 1 o'clock p.m.
And you said Pretorius had left at some point in the afternoon, right?
Yes,
And would you say Pretorius left before or after Rocky's accident?
I just know that they left some point that day.
And AEC continued pushing rail cars after Pretorius left, right?
Yes,
And Rocky then, after finishing the east track, moved to the west track to sample, correct?
correct.
And you stated several times in your deposition that you were actively pushing cars in Rocky's direction, south along the spur track, right?
That is correct.
And you also stated that Rocky was working from north to south, right?
Yes, I believe so.
So Rocky's about right here, and AEC is pushing, as you just mentioned, 3 or 4 cars at one time in Rocky's direction, right?
Yes, we normally push 3 or 4 cars. That is just how we do it.
And you didn't warn Rocky that you were pushing cars, did you?
I don't see why we had to warn him because we were making sure that we didn't bump into him anyway.
In fact, you mentioned you didn't need to warn Rocky because he was a big boy, correct?
Everything was so open and obvious, anyone could have seen them for themselves.
But you didn't need to warn him that you were pushing rail cars.
I mean, we made sure to leave the gap and everything. I don't think we had to.
And you said you were working in the loading platform at the time of the accident, correct?
I was up on an elevator platform.
And would you recognize that viewpoint if I showed it to you today?
Yes,
Is this an accurate view of the loading platform?
yes, I believe so.
Your Honor, I'd like to enter exhibit 12 into evidence. Permission to the jury. So this is the view that you had when you were looking at Rocky at the time of the accident.
Yes,
And you said that you left a 15-foot gap in between his rail cars,
that is,
an exact 15-foot gap, correct?
that is what we left.
From 460 feet away, the 15-foot gap, and you didn't think to warn Rocky that you were pushing cars in his direction?
We made sure to leave the 15-foot gap. We normally use about 3 to 4 people, so, I mean, I didn't push the rail car under there, so
But AEC was actively pushing the rail car, correct?
it's hard to say who actually pushed that rail car because it's, like I said, we use 3 to 4 people when we normally push rail cars, so it's very hard to say who pushed that very last.
Well, who else was on property besides Pretorius and AEC that day, right?
Pretorius, like you just said.
And Pretorius had left at the time of the accident though, correct?
I'm not sure when they left, but I know they left at some point there.
Do you need to be refreshed once again?
If you would like to,
For the court and for the record, I'm reading from page 5, lines 17 through 18. In reference to Pretorius, yes, they had their engine out there most all day, but at some point they left. Just don't recall when that was. But we started pushing cars ourselves after they left. Does that refresh your recollection?
that does.
So you would say that Pretorius was gone at the time of the accident, right?
I would also say that they were there most of the day,
But they were gone at the time of the accident, correct?
correct?
And you stated several times in your deposition that you were worried, when you were pushing cars, you were worried that that would push Rocky off, right?
I just wanted to make sure we didn't bump into the car that he was second.
And you also said that you were worried that it would push Rocky off and knock him down.
Something along those lines, I believe, yes.
Thank you. No further questions, Your Honor. Regret.
Briefly. Hi, Mr. Control. So why didn't Armadillo use their own grade samplers?
By federal law, we're not allowed to.
And you mentioned that you were a football field away when this accident happened, but what did you observe?
I saw him stab the probe down into the hopper, saw him pull it out, swing it upside down and empty it. That's when I saw the bright flash. It made me realize that he'd come into contact with that power line.
Thank you, Mr. Control. Your Honor, I have no further questions.
You may step down. Thank you. This is defense, we should not further with.
Yes, Your Honor, the defense of Officer B. Jones. Good afternoon, Ms. Jones. Would you please introduce yourself to the jury?
My name is C.B. Jones,
Where are you from?
Zigzag, Oregon.
What do you do for a living?
I actually testify as an expert witness in the field of safety consulting.
And how are you involved in this case?
Armadillo Elevator Company hired me to look into the circumstances leading up to the accident involving Mr. Rhodes and determine who might be responsible for the accident.
Now, before we get into your investigation, I want to talk a little bit more about your background. How long have you been a safety inspector?
About 15 years since I retired from OSHA.
And just so we're clear, what is OSHA?
That's the Occupational Safety and Health Administration.
How long did you work for them?
About 20 years, and then I decided to become an expert witness.
And just to clear the air, do you get paid for your work as an expert witness?
Yes, this is my full-time job, so I get paid for my research, investigations, and testifying.
Now, could you tell us what your work looked like as a safety inspector?
I focused on mainly two things. My primary job was to go to businesses and inspect the premises to see if there were any safety issues. If there were, I would then issue citations for the companies not following safety protocol.
Well, you mentioned two things. What was the second one?
Unfortunately, sometimes there would be an accident and I would, before I got to inspect the company, if that was the case, I would have to go in and investigate the accident to determine the cause.
Do you recall how many accidents you've investigated over your career?
I'm not sure the exact number, but definitely over a dozen, at least two of which were electrocution accidents like this one.
And could you talk to us a little bit about your qualifications to do this type of work?
Well, I had extensive training through OSHA mainly. They have a robust training program on how to conduct investigations in various types of safety fields, like industries that follow guidelines separate from OSHA. And I went through 2 different training courses on investigations specifically dealing with accidents.
What did that training entail?
I was trained on how to do everything that I did in this case. I was trained on how to conduct site visits and how to determine the relationships between facilities and their equipment. Once I completed that step, I also learned how to review any available information about the accident and analyze what happened against the prevailing safety standards in that given field.
Did you have the chance to review anything before testifying today?
Yes, I reviewed all the depositions that have been taken in this case. I read the sworn statements that were given and looked at all of the exhibits that the plaintiff's expert also reviewed, which described the scene of the accident and the overall circumstances leading up to it.
And are those the standard types of materials that a safety inspector such as yourself would review when investigating this type of accident?
Yes, typically this type of evidence like guidelines, measurements, and accident photos are the gold standard to use in evaluating the safety of a facility after the fact.
Now, let's talk about what methods did you use while investigating this accident?
I made a site visit to where Mr. Rhodes' accident occurred and analyzed how the facilities and practices measured up against the applicable safety standards. And in this case, the Lone Star statutes and the National Electric Safety Code. I looked to see if anything listed in the depositions or materials differed from what I personally observed. And then I determined what responsibility any party had regarding potential safety violations.
Did you reliably apply those same methods to this case?
Yes,
And were you able to come to an overall opinion about what happened in this case?
yes.
Your Honor, at this time, the defense would like to tender this witness as an expert in accident investigation.
Your Honor, may I have a brief word here?
You may.
DB, have you ever been published?
No.
Have you ever been peer reviewed?
No.
Now, I want to get into your time in OSHA a little bit more in particular. Now, you mainly worked in the office, correct?
Yes,
And in fact, a majority of your time was policy, right?
correct.
And a majority of, you only investigated a dozen or so accidents in particular.
Right.
And during your time as a safety consultant, it was several more,
Yes,
correct? And only 2 were electrocutions.
yes,
So a majority of your work has been in regards to workplace safety policy.
yes.
Your Honor, we would first raise an objection to under 702A. We believe this witness has not met those qualifications.
702A. Your Honor, I believe this witness has met this qualification. She has almost 30 years of education and training through OSHA, including 2 accident investigation trainings. And not only were those just one type of accident, but in a variety of the type of accident. And I can go on.
Go ahead.
Your Honor, can I also request what field are you getting?
Accident investigation.
Accident. We are requesting limiting that this witness be restricted to policy, workplace safety policy. This witness has only investigated a few accidents in the course of his 40-year career. The majority of her time has been in policy work.
All right, the court is going to accept this witness as an expert in the area only. Thank you.
Ms. Jones, you just mentioned a moment ago that you had formed an opinion about what happened in this accident. Would you tell the jury a little bit about that?
Excuse me, my core opinions are based off of. Excuse me, they're split among each party, and I evaluated their responsibility and how they contributed to the accident.
Well, let's take those one by one and we'll start with Armadillo. What was your overall opinion on their responsibility based on your investigation?
Based on my investigation, I do not believe they were at fault for this accident.
Why do you say that?
Based on my investigation, they had the most passive role out of anybody. All they did was ask Austin Grain Sampling to send someone out to sample the grain. They didn't build the tracks, they didn't own the rail car, they didn't build the power line, and they did not train Mr. Rhodes.
Did Armadillo break any rules on the day of the accident?
Not that I'm aware of.
Now, let's talk about the victim in this case, Mr. Rhodes. What was your overall opinion of his responsibility based on your investigation?
Well, I'm in no way saying that Mr. Rhodes' passing was entirely his own fault, but unfortunately, I believe Mr. Rhodes did not exercise the care that he should have during his work, and combined with unsafe work conditions contributed to the accident.
Why do you say that?
During my review, I analyzed some safety rules and guidelines that Mr. Rhodes was instructed to follow as a grain sample. I found no evidence that he conducted a hazard analysis or called the power company to de-energize the power line before he began working that day. Mr. Rhodes was instructed to keep his grain probe more than 6 feet from the power lines, but unfortunately.
Objection, Your Honor, speculation. We believe that Mr. Rhodes, we don't know what Mr. Rhodes saw that day, and this witness does not have personal knowledge of what Mr. Rhodes did that day. We believe it is not provable that Mr. Rhodes did not keep his grain probe within those 6 feet. We believe that.
So the statement was the 6 feet?
Yes. Within
That's what
6
you're objecting to?
Yes.
I believe that it's been proven that this grain probe came within 6 feet of the power line as he was electrocuted by it.
I'll allow it.
So let's go ahead and move on. So what fault, if any, did your investigation show that Mr. Rhodes had in this accident?
A small amount, if any at all. I think he was just a victim of being in an unsafe work condition because of someone else's actions and then made some mistakes at work. Any other day, mistakes might not have been so costly.
On the day of the accident, did Mr. Rhodes follow all the rules that he should have?
Unfortunately, no, he was not supposed to bring his grain probe within 6 feet of the power line, but obviously he did. He also was supposed to ask for a disconnect in any power lines that may be near where he started working, which he didn't do either.
Now let's move on to your next opinion. We're going to talk about Pretorius Railway. What was your opinion of their responsibility based on this investigation?
Well, they're the ones that own the railroad tracks. So the company also has an easement across Armadillo Elevator Company's land. So they have some responsibility to make sure that area is safe.
Why do you say that? They have that responsibility?
The railroad company has a duty to make sure that their tracks are clear of danger. I mean, I know from the documents I reviewed, they typically have inspectors out there once or twice a month. Their railroad car was the structure that Mr. Rhodes was standing on when he made contact with the power line, which ultimately electrocuted him.
So what fault, if any, do you believe that Pretorius Railway had in this accident?
Based on my investigation, the railroad company had their engine out there all day long on the date of the accident. So you'd think they were the ones that put the car where it was underneath the power line. I found no evidence that they checked to see if they were leaving cars in a safe location relative to the power line.
Now let's move on to your final opinion, Big State Power Company. What was their overall responsibility based on your investigation?
I believe they have the most responsibility in the accident, if not all.
Why do you say that?
Well, obviously they built the power line. They were supposed to have it at 26 feet, but they didn't follow the rules given by the National Electric Safety Code.
Well, how are they not in compliance with the National Electric Safety Code?
The standard requires the power lines have to be 26 feet off the ground. On the day of the accident, the power lines were only 24 feet, 2 inches, which is almost 2 feet below where they were supposed to be.
Who was responsible for maintaining the power line once it was built?
Big State Power Company.
And who was responsible for making sure that the power line was up to the National Electric Safety Code?
Big State Power,
And who actually owned the power line that electrocuted Mr. Rhodes?
Big State Power.
Thank you, Your Honor. It's one of this witness agreed with or cross examination. Excuse me.
May I proceed?
You may.
Phoebe, you retired from OSHA to make more money, correct?
Yes,
In fact, your direct quote is that being an expert witness is more lucrative.
yes,
Bias is important in an investigation, right?
right.
Let's talk a little bit about your investigation. You said Rocky Roads was entirely at fault of this accident, correct?
No,
Is your testimony today that you are not entirely blaming Rocky Roads for this accident?
no,
You remember taking the deposition?
yes,
Do you remember being under oath?
yes.
Your Honor, permission to retrieve the witness's deposition.
You may.
For the record, I am on page 3, starting from line 11 to line 12. Yes, I came to several conclusions. First and foremost, this accident was entirely the fault of Rocky Roads. He failed to exercise even the slightest care for his own safety. So you said Rocky was entirely at fault for this accident.
Yes, in the deposition.
Now, Rocky had gone to the work site the day beforehand, correct?
Yes,
And that day, he noticed something at the work site, right?
right.
He noticed mud. Now, mud was a hazard to his job, right?
Yes,
It created a risk for him.
yes,
So he analyzed the site, correct?
Yeah.
Noticed a hazard, correct?
yeah, the day before,
And then left.
right,
So he did his job then, correct?
the day before, correct.
Now, you said the power line was 10 feet above Rocky's head, correct?
Right,
Let's move on to Pretorius. Now, you said Pretorius did safety checks of the rail tracks, right?
yes,
Now, they did these checks every 2 months, correct?
Yeah.
Is Pretorius in a power line company?
No.
No. Does the power lines ever come in contact with the rail cars?
No.
In fact, the power lines were about 10 feet above the rail, correct?
yes,
And Pretorius's job is to make sure the railroad is safe, right?
yes,
Now, you are aware that Pretorius was there the day of the accident, right?
yes,
But you also read the deposition of Alexander Bell, right?
Yep.
Mr. Bell said that they were moving, the last car that Pretorius moved was 2 cars south of the car this accident occurred on, correct?
correct,
And he also said that Pretorius had left by 3:22 that afternoon.
right,
Now let's move to AEC. AEC needed rock, right?
Yeah.
They can't sample their own grain. So they knew a grain sampler would be out there that day, right?
yes,
So the Lone Star statute states the man, person, firm, or corporation responsible for bringing a worker within 6 feet of the line, correct?
yes,
So AEC knew that a grain sampler would be on top of those cars.
yes,
And they knew that that grain sampler would be within 6 feet of that power line, right? And AEC didn't call to de-energize that line either, did they?
No.
Now, you said AEC had a passive role in this accident, correct?
yes,
Now, AEC was pushing cars on the same track as Rocky, right?
Yeah.
While his back is turned, right?
yes,
Without warning him that they were moving cars on the same track,
yes,
without warning him about the power line on the same track as him,
right,
while he was stationary, correct?
yes.
No further questions, Your Honor.
Redirect.
Greatly, Your Honor. Ms. Jones, you were just asked a lot about a hazard analysis performed on June 15th. On June 16th, 2020, did Rocky Roads perform a hazard analysis of the scene?
No,
Objection, Your Honor, speculation. We don't know if Rocky did perform hazard analysis that day. We don't know what Rocky did. We don't know if Rocky saw the power line.
Objection overruled.
Thank you.
Yeah.
I believe she's answered.
Remember. Just witness
May step down. Does the defense wish to call any further witness?
No, Your Honor, the defense.
All right, before we take a 5-minute break before closing arguments, are there any further motions to be made?
Yes, Your Honor. The plaintiff would like to make a motion for directed verdict. AEC, by bringing in these third parties, had a burden on themselves today. They had the burden to show that Rocky Road's death was caused by either Pretorius Railway, Big State Power, or Rocky Roads himself. And in terms of Pretorius Railway, they had the burden of proving that Pretorius was negligent by proving that Pretorius made an unreasonable risk of harm. We have seen nothing today that Pretorius made an unreasonable risk of harm. They were gone at the time of the accident. Additionally, they had to prove that Pretorius knew of that harm. Pretorius had no way of knowing that AEC would continue to push rail cars after they had left the scene of the accident. They also had to prove that Rocky Roads did not know of that harm. We proved that Rocky Roads did not know of the moving cars harm. But the last factor that they had to prove was that Pretorius failed to warn Rocky Roads or make that harm safe. Again, we've heard that Pretorius had left the scene of the accident. They had no duty to Rocky Roads to let them know that something that they wouldn't have known. Additionally, they had to prove that Rocky Roads or Big State Power was negligent by proving that they failed to use ordinary care that a reasonable person would under the same or similar circumstances. We have put on testimony today that Rocky Roads looked at the site, decided it was too muddy the day before, and then left work. There's no evidence to show that he did not do a site hazard analysis the next day. Rocky Roads was performing under an ordinary care standard. He did his job like he was supposed to do, but AEC should have warned Rocky that they were moving cars in his direction at the time he would be on top of the rail car. In terms of Big State Power erected a taller pole to mitigate the damage and offset the height difference. They have not proved that Big State Power did not act in ordinary care. Because AEC has not proven all three of their burdens in today's case, we would ask that the court grant our directed verdict motion.
Your Honor, it is absolutely possible that a jury could find that it was more likely than not that each of these parties were the sole responsibility, or not the sole responsibility, but contributed to the death of Mr. Rhodes. Pretorius Railway had engines out there on the day of the accident, and it is disputed who was pushing the last rail car underneath that power line. Further, they had a site inspector come out to their premises once or twice a month over the course of 3 or 4 years, and they never did anything about it. Big State Power Company built the power line below code, and whether or not those poles allowed for it is irrelevant because they're the power company and they should be building those proper lines up to standards. And if they can't, they shouldn't do it. Also, Rocky Roads, the fact that he performed a hazard analysis on June 15th is again irrelevant because he performed it that day. We're not going to assume that he performed it the next day. So for all these reasons, Your Honor, we ask that this motion be denied.
All right, having considered arguments, counsel, the court is going to deny the motion for directed verdict. And we will take a 5-minute break, and then proceed with our closing arguments.
All right.
Y'all stand down. Got 5 minutes.
What?
They're gonna use it 5 minutes.
Let's.
Josh, do you want a 5, 1, and 30 or just a 1 and 30?
5 or 3.
Okay.
Just because I need to.
Oh, yeah.
I'm gonna use that one, but I'll just set it on later done, but I just. Not think we should.
All rise for Judge Burton.
Please be seated. Ladies and gentlemen of the jury, at this time, the council will offer for your benefit what we refer to as closing arguments. We will proceed with plaintiff first, and then we'll hear from the defendant, following which you'll be read your jury instructions and you will take leave to render a verdict. All right. Counsel ready?
Yes, Your Honor. Before I begin, I reserve the remainder of my time for rebuttal.
You may listen.
May I proceed?
You may.
Your Honor, opposing counsel, Mrs. Rhodes, members of the jury. It is better to be safe than sorry. And AEC wasn't safe, and they're not sorry. AEC, or Armadillo Elevator Company, is a grain elevator. And they need 3 things to keep that business running. First is railroad tracks. Pretorius provided those railroad tracks. They gave them cars and they would take them out when they were done. Pretorius checked those tracks, did their job, and kept AEC moving. The second thing they needed was a power line. Big State Power built that power line solely at the use of AEC at AEC's request. And the third thing they needed was a grain sampler. Now, that's where Rocky comes in. See, Rocky was a lot of things. He was a father, husband, local high school teacher. But on this day, at this time, during this accident, he was an employee of AEC. Members of the jury, you heard on June 15th, Rocky went to this work site. He noticed something. He noticed a hazard. Because Rocky knew it was better to be safe than sorry. You see, Rocky didn't take chances. But on June 16th, the decision was out of his control. Because AEC was taking the chances, and AEC wasn't being safe. Now, in today's case, we have the burden of proof to prove that AEC was negligent. Now, what that means is we have to show that it was more likely or not, or preponderance of the evidence, that AEC was negligent in the death of Rocky. Now, negligence is a term, so I've created a demonstrative to sort of help you visualize it. Now, the first element of negligence is a condition posing an unreasonable risk of harm. You heard multiple witnesses today talk about the fact that pushing rail cars on the same track as Mr. Rhodes without warning him created an unreasonable risk of harm. That Mr. Rhodes would either fall or be pushed. And AEC kept pushing cars. You heard they were moving 4 to 3 cars at a time on the same track. That created a condition posing a risk of unreasonable harm. AEC knew of that harm. You heard Chris Kitchell testify that they were aware of the danger of pushing cars on the same track as Mr. Rhodes. 5 times he said that they were worried about hitting Mr. Rhodes off the car he was standing on. AEC was aware of the danger that comes from pushing cars, and they knew it. Rocky didn't know. You heard testimony from Mrs. Rhodes earlier today. Rocky had never been to this work site before. And when Rocky went to this work site, he checked for the safety that was relevant to him. But he was never informed by AEC about the dangers of this work site, and in particular about the moving cars that were moving behind him, towards him. Rocky didn't know that they were moving cars. Now, this last element is an or. So we only have to prove one of these, but we have proven both of these. The first is that AEC did not warn Rocky. You heard testimony today from Chris Kitchell how AEC didn't warn Rocky about anything. Rocky was a big boy. They didn't have to tell him. But AEC knew that there was a dangerous condition in that work site, and they failed to inform him of that dangerous condition. They failed to tell him about the moving cars. And this last one, AEC failed to make the condition safe. AEC had all the power in this case. AEC was the only one moving rail cars at the time of the accident. You heard multiple witnesses testify to that fact, that AEC solely was moving cars. You heard their own expert witness testify that the last car that Pretorius moved was 2 cars south of the car Rocky was standing on. But Pretorius kept pushing cars south, and they kept moving them down. They didn't stop, even though they knew Rocky was there. They knew the risk of harm was there, and they failed to mitigate. Now, AEC failed to make the condition safe. Now, AEC has made a lot of arguments about other people being responsible. Those other people weren't pushing cars at that time. First, let's talk about Rocky. At the time of the accident, you heard their expert testify that Rocky was stationary. His back was turned to where the cars were coming from, and he was sampling, dumping out grain. Rocky wasn't even moving. Rocky couldn't control this. Rocky didn't have the option to. This was in AEC's hands. You then heard about Pretorius Railway. Now, to reiterate what I said earlier, Pretorius was gone. They weren't even there at the time of the accident. So instead of stopping when Pretorius left, they just kept pushing. 4 cars of grain on the same track. And when those 4 cars hit Rocky Rhodes' car, that caused him to stumble. Now, the defense has made a big deal about power lines, big state power. The power line being short isn't the proximate cause of this accident. Whether that power line was short or not, we don't know whether Rocky saw. We don't know what Rocky did that day, whether he did a site hazard analysis, whether he saw the power line. But what we do know is that AEC was pushing cars towards Rocky while his back was turned. And that push pushed him into that wire. That even if that wire had been in regulations, an accident still would have occurred and Mr. Rhodes still would have been harmed. AEC has the sole control over this piece. There's no one else pushing cars on their property at this time. This is their responsibility. The judge is going to give you some jury instructions. The first question is, was AEC negligent? We believe that we've met that burden. That AEC was negligent in failing to stop pushing rail cars or informing Mr. Rhodes that they were pushing rail cars on the same track. Second question is percentages of blame to the various parties in this case. We believe that we have shown the majority of the blame in this case falls at the feet of AEC. Because regardless of any other conditions, this push, this hit of car against car is what caused Mr. Rhodes his death. AEC negligence in terms of the rail cars caused this death. We ask that you return a verdict that AEC was negligent in the death of Rocky Rhodes. Thank you.
Can remove
Yes.
this.
We can have 1 minute.
Yes, you may.
Everyone can read this. Is it close enough?
Not for me.
Or I'm gonna explain it to you. Your Honor.
You may.
Citizen Council. Members of the jury. Earlier today, my co-counsel, Ms. Pasquale, came before you and she told you the tragic story of Mr. Rhodes. How in a brief moment, his grain sampling probe hit a power line and he lost his life. Now, Ms. Fontenot also came before you today and she tried to sell you a different story. But members of the jury, we actually do agree with some of what Ms. Fontenot said. We agree that this is a tragedy. We agree that Mr. Rhodes should still be here today. And we agree that the right party should be held responsible. But when she told you that Armadillo Elevator Company was responsible for that accident, that's where our agreement ends. Members of the jury, we're not here today to place all of the blame on this victim, but we are here today to make sure that this does not happen to anyone else. Because when you don't play by the rules, someone can get hurt. Now, the plaintiff has brought a suit of negligence against Armadillo, and this means that they have to show you that Armadillo had a duty to Mr. Rhodes, that they breached that duty, that the breach was the cause of harm, and the harm itself. Now, they also have the burden to show you that by preponderance of the evidence, and that burden has sat on their table today, and it has not moved this entire trial. And if they have not shown you that it is more likely than not that Armadillo caused this accident, then they have not met their burden. Ms. Pasquale has also made a promise to you today that we would show you how it's not Armadillo, but rather the other companies involved who were responsible for this accident. So let's show you how we kept that promise. Later today, you'll go back to deliberate. You'll receive a verdict form that's going to look like this. I'm going to ask you two questions. The first one will simply ask you to answer yes or no if the party was responsible for Mr. Rhodes' death. The second question will ask you to assign a percentage of fault to that party, if any. And as you can see, there are four parties listed here: Armadillo Elevator Company, Big State Power Company, Pretorius Railway, and Rocky Roads. Now, I want to break that down and go through those one at a time, asking both questions about each party. And we'll start with Armadillo. Now, the plaintiff has really wanted you to focus on Armadillo today, but members of the jury, the only reason that Armadillo is even involved is because they own the land. They did not own the rail car itself. They did not own the railroad tracks. They did not employ Mr. Rhodes. They did not give him his training, and they definitely didn't build the power lines that electrocuted him. But the plaintiff doesn't want you to think about those things, and they don't want you to look at those things. But I'm the type of person, when someone tells me not to look at something, makes me want to look even more. And when you look at what the plaintiff is trying to distract you from today, you see that Armadillo wasn't responsible at all, but rather the other parties. You even heard today an expert testify that Armadillo was the least likely out of any other source to have caused this accident. For these reasons, members of the jury, we're going to ask that you write no as to the question for Armadillo Elevator Company and assign 0% of the attributable negligence. Now let's move on to the victim, Mr. Rhodes. As I said, we're not here today to place all of the blame on him, but unfortunately, there were rules he could have followed to protect himself. You heard from Mr. Rhodes' wife today, Bailey Rhodes, and she told you about the Austin grain sampling instructions that Mr. Rhodes had been given and signed, stating he thoroughly understood them. But on the day of the accident, some of those rules weren't followed. You heard that Mr. Rhodes was not supposed to bring his grain probe within 6 feet of any power lines. And Ms. Pasquale showed you how far above his head that power line would have been. Members of the jury, it was only 3 feet. It was right above his head. On the day of the accident, Mr. Rhodes knew before he went to work that day that that power line was too low. You also heard that Mr. Rhodes was supposed to ask for that line to be de-energized when working in close proximity to it, but that didn't happen either. For those reasons, members of the jury, we're going to ask that you write yes as to the question for Mr. Rhodes and assign 10% of the attributable negligence. But again, all of the blame should not be placed on the victim. In fact, it is the other parties involved that should bear most of the responsibility. So let's talk about Pretorius Railway. They own the railroad tracks and the railway car that Mr. Rhodes was on when he died. And you heard today that Pretorius Railway had one of their engines out there on the day of the accident, pushing cars underneath that very power line. Now, when they pushed that car underneath the power line, they knew it was too low. Why had they pushed it there before? And why had they left it? You also heard they had a site inspector go out to the railway site at least once or twice a month, and that power line had been there 3 or 4 years. And they never did anything about it. For those reasons, members of the jury, we're going to ask that you write yes as to the answer for Pretorius Railway and assign 10% of the attributable negligence. Finally, Big State Power Company, the company that owned and built the power line that electrocuted Mr. Rhodes. Now, you heard time and time again today that the absolute minimum that power line should have been was 26 feet. On the day of the accident, it was 24 feet and 2 inches. It's almost 2 feet below the absolute minimum. And did Big State Power Company do anything to fix this? Not until it was too late. And because that power line was not up to the right code, Mr. Rhodes' grandparents came into contact with it. Strike one. You also heard how Big State Power Company was asked to put a disconnect in that power line so grain samplers like Mr. Rhodes could ask for it to be de-energized when not in use. But that didn't happen either. And you heard that the reason given for this was it would cost too much. Well, because that disconnect cost too much, it cost Mr. Rhodes his life. Strike two. But it wasn't enough for Big State Power Company to simply fail to follow the rules. No, they admitted that they knew the power line was dangerous. You heard that a representative from their company told police that it was only a matter of time before someone got into those power lines. Strike three. When you don't play by the rules, someone can get hurt. And members of the jury, you don't have to take it from me or our witnesses, but listen to their own expert witness today. He told you that when you don't follow the rules, it could be the very difference between life and death. And today, the plaintiff doesn't want you to look at the man who didn't follow the rules, or the company who didn't build the power line up to the right height, or the company that owned the railway cars. They don't want you to see these things. They want you to ignore this evidence. Members of the jury, we're going to ask that you write yes as to the first question for Big State Power Company and assign 80% of the attributable fault. Members of the jury, I don't know if there's a right ending to this story today, but I can tell you the wrong one. And it's the one that the plaintiff is asking you to write. We came before you today and we asked you to do something that the plaintiff never did. To look at all of the evidence and to be sure that the right party is held accountable. Because when you don't play by the rules, someone will get hurt. We ask that you find Big State Power Company liable and return a verdict for the defense. Thank you.
Believe you reserve some time.
Yes, can I ask how much time I have remaining?
1 minute and 4 seconds.
Before I begin my,
You may.
May I proceed? You may. Members of the jury, the defense came up here. They said that AEC had nothing to do. You heard testimony time and time again today about how this rail car was being pushed at again and again. That wasn't by Big State Power. Big State Power wasn't pushing cars. That wasn't by Pretorius. They were gone already. That wasn't by Rocky. They couldn't push those cars. AEC was pushing those cars. AEC pushed Mr. Rhodes into the power lines over his head. AEC was the sole party responsible for the movement of those cars at the time of this accident. Now, their case theory relies on an expert who went from saying Rocky had a small amount of responsibility to this accident being entirely his fault. We have shown a reliable certainty that AEC knew about the danger of pushing these cars, saw the danger of pushing these cars, and continued to push these cars. We ask that you find them there. Thank you.
All right. Ladies and gentlemen of the jury, the case will now be turned over to you for your consideration. Will the bailiff, will monitor the door of the jury room, and when you have finished your verdict, please not. Thank you.
All right.
Thank you, Madam.
Yeah, well, in
Can we get a picture before the judge on the back?